Today, we're diving deep into one of the most critical aspects of your child's education, the Least Restrictive Environment, or LRE. What is it? Why does it matter to your child's IEP? And how does the Rachel H. test influence decisions about where your child learns? Hi, welcome to Disability Ed Pros. I'm Diana Fannin, epilepsy warrior, school psychologist, special education director, and autism mama. On this channel, I share evidence-based strategies, advocacy tips, and personal insights to empower parents of children with disabilities. At the end of this video, you'll understand the legal framework behind the least restrictive environment and how the Rachel H. case has shaped inclusive education. Stick around because this information can make a huge difference in advocating for your child's educational needs. So what is the least restrictive environment, or LRE, anyway? The concept of LRE comes directly from the Individuals with Disabilities Education Act, or IDEA, and this law ensures that children with disabilities have the right to be educated in the least restrictive environment possible. But what does that really mean? Simply put, it means that schools must prioritize placing your child in a general education setting with appropriate supports before considering a more restrictive environment. So let's say your child is autistic and maybe they have a few academic needs as well as they're in need of some behavioral supports. So when looking at placement and considering LRE, the school should first try to accommodate your child in a general education classroom by providing accommodations such as extra time on tests, one-on-one support, specialized instruction, and maybe something like headphones in case the classroom is too noisy and there's some sensory input challenges. Only if these aren't sufficient should the district considering moving your child to a more restrictive placement, such as a special education classroom. Why is this so important? Your child must have the same opportunities to interact with peers, engage in the same curriculum, and develop social skills in a typical classroom setting. Research shows that students who spend more time in inclusive settings generally achieve better academic and social outcomes over time. So now let's get into the Rachel H. test. This comes from a 1994 court case involving a young girl named Rachel Holland. Her parents wanted her to be fully included in the general education classroom, but the school district argued that she would be better served in a special education setting. The court's decision in this case became a landmark for how we think about inclusion and the LRE, and more importantly, how we make decisions about it. Because the judge established a 4-part test to guide schools in deciding whether a student should be placed in a general education classroom. Now, let's break down those 4 factors. So, factor 1, educational benefits. The first factor looks at the academic benefits of placing your child in a general education classroom. Will they be able to learn and progress alongside their peers? Now, this doesn't mean they have to progress at the same rate. For some students, being in a general education classroom with the right supports can lead to significant academic growth. Now, imagine your child struggles with reading. The school might provide a special education teacher who provides services in the classroom rather than pulling them out for separate instruction. This way, your child still participates in the general education curriculum while getting the support that they need. Factor 2, non-academic benefits. The second factor considers non-academic benefits like social interaction, communication skills, and exposure to a broader range of experiences. This could be things like communication skills, social skills, and just other kinds of things that happen in the classroom. And these are crucial for developing well-rounded individuals. And your child is exposed to and has the opportunity to learn these important skills just by working on group projects, participating in class discussions, or even just passing other students and peers while walking through the classroom. And these opportunities may occur less frequently in a more restrictive setting. Factor 3, the effect on the teacher and other students. This factor examines how your child's presence in the classroom affects the teacher's ability to teach and the other students' ability to learn. This doesn't occur in a vacuum, so we do have to think about that. It's about balancing inclusion with the needs of the entire class. If your child requires significant one-on-one attention, the school might need to provide a paraprofessional to ensure that their needs are met without disrupting the class. So that doesn't automatically mean that the student would need to be moved to a more restrictive setting. And that is actually an example of how the student could be served with additional support in the general education classroom. Factor 4, the cost of supplementary aids and services. We got to talk about money. The fourth factor, it considers the cost of providing the necessary supports. Schools are required to provide accommodations, but this factor does acknowledge that resources are finite. Schools are notoriously underfunded, but we still have to talk about this. They do have to provide services, but if your child needs a specialized piece of technology to participate in the general classroom, the school will consider both the benefits to your child and the financial implications. I will say though, in my experience, I have yet to see cost as a factor that prevented a school from keeping a child in the general education setting. I'm sure it has happened, and I'm sure it could be legitimate. I just don't think this is usually the reason for a more restrictive placement, but that's just my experience. Okay, so why all of this matters. Each of these factors must be weighed carefully with the ultimate goal of providing the most inclusive environment possible for your child. So now we get to a recent court case that was in my backyard in Southern California here. And it's important to know that Rachel H. has been around for nearly 30 years and has been a cornerstone in talking about and analyzing the LRE, or the Least Restrictive Environment. And it is incredibly important, but it is not black and white, right? We can't look at Rachel H. and say there's a yes or a no every time. So this case, DR, the student, highlights how interpretations of LRE can still be contentious and there's still a massive gray area. So here's what happened. DR's parents alleged that the school district was not providing their child with a free, appropriate public education or FAPE in the least restrictive environment. And they argued that DR wasn't being given the chance to learn alongside non-disabled peers with the necessary supports as mandated by the Individuals with Disabilities Education Act, or IDEA. And this happened when the district recommended a change in placement to an SDC, which is a special day class, which is a much more restrictive setting. And parents were in disagreement with that. So when that happened, they enrolled DR in a private school and sought reimbursement from the district. So this case initially went before the Office of Administrative Hearings, or OAH, which ruled in favor of the district. And then the case went to the federal district court, which upheld the decision also. And then, and this is where things changed, the Ninth Circuit Court of Appeals saw it differently. On appeal, they partially overturned the district court's ruling, finding that the district had not, in fact, offered DR an appropriate education in the least restrictive environment. Now, this case is significant because, as I mentioned, it just underscores the fact that the legal landscape around LRE is still evolving. Even with guidelines like Rachel H., courts continue to interpret what constitutes an appropriate and inclusive education under the IDEA. Now, the lead attorney on the case, David German, has a quote which I love, and so I'm going to share it here. The decision makes clear that district members of the IEP team can no longer rely on a presumption that segregation will be beneficial, hopefully requiring district personnel to provide actual evidence of how a student can supposedly benefit from time away from the general education classroom will force them to confront the overwhelming evidence that inclusion works for students. So, what does this mean for you as a parent? It highlights the importance of being vigilant and advocating for your child's rights to be educated alongside their peers whenever possible. The IDEA makes it clear that students with disabilities should only be removed from regular classrooms when absolutely necessary, when the nature or severity of the disability makes it impossible to achieve satisfactory education, even with the use of supplementary aids and services. The DR case reminds us that even when a district believes it has met its obligations, there is room for disagreement. And parents have the right to challenge decisions that they feel aren't in their child's best interest. And this is a powerful example of how parents can use the legal system to advocate for a more inclusive education for their children. So there you have it, the least restrictive environment and the Rachel H. test. Two critical concepts in ensuring that your child receives an education that is both inclusive and effective. Remember, as a parent, you have the right to advocate for your child's placement in the least restrictive environment. Knowing about things like the Rachel H. test empowers you to ask the right questions and ground them in law, and then push for the best possible outcomes. I'd love to continue the conversation in the comments, so if you found it helpful, let me know. If you have any questions, drop that in the comment as well. And if you have experience with this with a child or your children, let me know that too. I'd love to hear your experience with this. And I will see you again soon. Thank you.